Accused in a murder case was arrested and remanded to judicial custody. How many days a magistrate may authorize the detention of the accused person in custody if the accused furnishes bail? Option A 60 days, option B 40 days, option C 90 days, and option D 120 days. The answer is option C 90 days. When a person is arrested by the police, he is required to be produced before the magistrate within 24 hours if the investigation is not complete. The magistrate may further send him for police custody for a period not exceeding 15 days, and after the lapse of 15 days, the person may be remanded to judicial custody. Judicial custody is mentioned in section 167 Cr.PC. Judicial custody means the accused is in the custody under the supervision of the judicial magistrate, and judicial custody may extend to 60 days or 90 days. Judicial custody can be extended even to 90 days if the offence is punishable with death sentence, life imprisonment, or imprisonment for a minimum term of 10 years. How can the arrest of a person be made? Option A, by putting handcuff. Option B, by actually confining him in a room. Option C, by actually touching or confining the body of the person to be arrested. Option D, none of the above. Here the answer is option C, by actually touching or confining the body of the person to be arrested. Section 46 Cr.PC says how an arrest is to be made. It says while making an arrest, the police officer or any other person making the same shall actually touch or confine the body of the person to be arrested. And if such person forcibly resists the arrest, the police officer or any other person may use all the necessary means to effect the arrest. Chapter relating to the plea bargaining has no application in the following offence. Option A, offence involving moral turpitude. Option B, offence affecting socio-economic condition of the country or committed against a woman or a child below 14 years of age. Option C, offences against senior citizens. And option D, none of the above. Here the answer is option B, offence affecting socio-economic condition of the country or committed against a woman or a child below 14 years of age. Chapter 21A Cr.PC deals with plea bargaining, and this chapter was inserted by the Criminal Law Amendment Act 2005. Sections 265A to 265L deals with the concept of plea bargaining. Plea bargaining is an agreement or a negotiation between the accused or the defendant and the prosecution. Here the accused agrees to plead guilty in exchange for certain concessions from the prosecution. The negotiation or the agreement between the accused and the prosecution is not applicable to all types of crimes in the case of plea bargaining. Plea bargaining is applicable for those offences where the maximum punishment is imprisonment for 7 years, or where the offence does not affect the socio-economic condition of the country, or where the offences are not committed against a woman or a child below 14 years of age. This means plea bargaining is not applicable to heinous crimes or grave crimes or serious crimes. Application for plea bargaining under Chapter 21A Cr.PC has to be moved by option A, prosecutor, option B, accused, option C, victim, and option D, victim on the direction of the court. The answer is option B, accused. Section 265B Cr.PC deals with the application for plea bargaining. As said, it is included in Chapter 21A of Cr.PC inserted by Criminal Law Amendment Act 2005. The application for plea bargaining is to be filed by the accused, containing brief details about the case relating to which the application is filed. It includes offences to which the case relates and shall be accompanied by an affidavit which is to be sworn by the accused. court can exercise the power under section 313 CRPC in questioning the accused. Option A, at any stage during the course of inquiry or trial. Option B, only after closing the evidence of the prosecution. Option C, only after calling upon the accused to enter on his defense. And option D, before concluding the arguments. The answer is option A, at any stage during the course of inquiry or trial. The power to examine the accused is explained in section 313 CRPC. Here the court can exercise this power at any stage during the course of inquiry or trial. The purpose of this section is to enable the accused personally to explain any circumstances appearing in evidence against him. As per the section, questions may be asked by the court without previously warning the accused. The answers given by the accused may be taken into consideration in such inquiry or trial and put in evidence for or against him. Power to commute sentence is vested with option A, appropriate government. Option B, court which passed the sentence. Option C, first appellate court. And option D, revisional court. The answer is option A, appropriate government. Under CRPC, commutation of sentences means the nature of the punishment is changed and converts it into a less severe form of punishment. And commutation of sentences are given under section 433 of CRPC. As per the section, the appropriate government has the power to commute the sentence in appropriate cases. Various sentences are eligible for commutation. For example, a death sentence can be commuted to any other punishment provided in the Indian Penal Code. Similarly, rigorous imprisonment can be converted to simple imprisonment, and a simple sentence can even be converted to a fine.